Hello there and welcome back to the Disability Law Show. Good to have you along for another week. John Scholes here, Tamar Agopian right there, disability lawyer at disabilityrights.ca. Off the top of the show each week, I always tell you the contact information. Good to write down and keep on your phone. You need to get a hold of Tamar and her team anytime. The phone number, toll free, of course. Consultations free, 1-855-821-5900. Email to back it up with, help@disabilityrights.ca. We will give those out to you throughout the half hour as we continue on here. We have phone calls, we have emails, we always have a main topic. This week it will be next steps when the insurance company cuts off your disability benefits. Tamar will be handling that. But we always start off, pal, of course, with the week that was, or a case of the day. What have you got cooking this week?
So much going on.
Yeah.
And what I like to usually focus on our shows, at the start of these shows, are things that we're seeing a lot of questions about. And one of the topics that came up quite a bit this week was related to disabilities that have a progressive element to it. And we do talk about this time and again on our shows, but they can be a little bit different because they are disabilities or health conditions that people have had for some period of time, sometimes years, and they get worse over time, and eventually it gets to a point where that individual cannot continue working. And disability insurers, invariably as they do, will resist these types of disabilities because they'll use your ability to continue working with these conditions almost against you as evidence that, well, why can't you continue working? And this is where the courts have weighed into conversations like this around the progression of a disability and whether or not it's a valid, quote unquote, valid disability. And it is. And this is the really key takeaway, is that I want people to hear from us that just because your disability got worse over time doesn't mean that in and of itself should disentitle you to long-term disability benefits. The kinds of situations or health issues that I'm thinking of include conditions like multiple sclerosis or Parkinson's, even some degenerative conditions in the back or spine or neck. Those are conditions that you might be diagnosed with, say, a Parkinson's on day one, but are able to continue despite tremors and other health conditions for a number of years afterwards. So if you're advancing a disability claim in a situation like this, what are the key takeaways? What's the advice? Get to the point, Tamar. Well, here's the point. The point is that you want to make sure that you've got key medical information that documents the change. I think that if you've got a long-standing family doctor, for example, who has monitored this condition for a number of years, that doctor may actually be in the best position, more than, say, a back specialist or a rheumatologist, or neurologist, depending on the condition. The family doctor might actually be able to speak to the fact that I've been treating my patient with this condition for a long time, here are the treatment measures, and here is why it has now come to a point where my patient needs to stop working. And that explanation, by the way, there's no box in the forms that the LTD insurer is going to provide you to actually fill in that information or have your doctor fill in that information to actually explain it. This is why the reports become so important, why I can't stand the forms that normally people get, because it's too easy for the doctor to just check off a few boxes, put in multiple sclerosis and say, you know, not able to work, prognosis is poor, and then away you go. That gets submitted to your case manager or case adjuster. Again, these adjusters don't have good training, don't have good background, and when they pick that up and they say, well, you were diagnosed in 1995 and continued working for 20, 30 years with this condition, how so? It must therefore mean it's either not severe enough, or they look for other reasons to identify why perhaps you stopped working. It's a work issue. You must want to retire. I've seen every excuse under the sun, other than to acknowledge the reality that conditions like this get worse over time. So, John, you know, I think that what I want people to understand is that these are claims that we absolutely can fight insurance companies on as well. So I want people to have the tools. I want them to understand, how do I submit this to the insurance company to get over that hurdle, to get them to accept my progressive disability as totally disabling, as meeting the test, as meeting the requirement. But if the insurance company continues to resist, Where do I turn? And I think that is really where we step in, where we excel at demonstrating to the insurers not only that the law is on our side, but cases like this medically are also very well supported. Usually there's multiple doctors involved in the care, and that then with the right commentary, the right approach in terms of the medical information can absolutely mean compensation for individuals arguably till the rest of their working life, which people with these conditions, this is what they need. This is what disability benefits are there for, is to support them for the time where they have to stop working and need to continue to rely on disability to survive with their bills and their family and of course, their health.
Based on your hypothetical, though, saying going back to 95 with MS or Parkinson's, the fact that those are known progressive diseases, shouldn't that kind of tell the insurance company, yeah, by the way, guys, when I told you about this initially, this is going to get worse and it's going to come to a point where I'm going to need my benefits?
Absolutely. It should be a no-brainer.
Right.
Right. I think the conditions that I'm seeing more resistance on are when you may have elements like degenerative disc disease in your spine, or perhaps you have an autoimmune condition, something like a POTS or EMS. There's all sorts of lingo. I don't want to bore our viewers on this, but those kinds of conditions are less known. You know, there's a lot of literature on Parkinson's and that development of Parkinson's, for example. Not to say that I haven't had a whole ton of Parkinson's cases, but I think where it starts to become controversial is how severe is the pain? How limiting is your function when you have inflammation in your body? When you're not having a flare of the condition, can you be functional and then therefore work? And that's what insurers will focus on. That's what the adjusters are looking for, is that those periods of time should theoretically be enough for you to work, and therefore we're not going to approve your disability claim. So yes, it should be a no-brainer, but it is not often. Again, because you have a combination of either emerging conditions or a constellation of issues happening together, and, you know, forms that don't allow doctors to explain exactly what is happening with that progression, and therefore moving that needle with the insurance company.
But at this point, you probably, as you said, have a team of doctors to back up the history that you have. So it really should, in the end game, you're going to win because you cannot work, and that's what it comes down to.
Yes, right? But a lot of the time, the specialists aren't available for 6, 8 months, 12 months, let's say. And so you might have to actually initiate your disability claim with just your primary treatment provider, most likely a doctor or a nurse practitioner, and only afterwards are you able then to access the additional medical information. And so don't be discouraged. This is a reality for everyone across our country. Our medical system is overburdened. We know this. This has still been happening post-pandemic, and it is not getting better with time. But it doesn't necessarily mean that the insurance company is justified in denying your claim or cutting off your claim just because you couldn't get in the door to see your specialist. We're getting down a rabbit hole here a little bit, but I think it is an important point because the medical information does become critical in not only getting approved for your disability benefit, but also ensuring that you have ongoing support for that. And so could you then do a phone call with your practitioner? Could you perhaps have your family doctor request records on your behalf and have that sent over to the insurance company? Lots of tools and tactics. But again, these are things that we do as part of our services for our clients. So if the insurance company is saying no in a situation like this, you do want to get the right advice. You want to call someone on our team, myself and others on our team, who have the ability to get in the door, get the information that we need, and then leverage that to get the results and the compensation that's entitled to.
We talk every week about a fantastic online tool called Pocket Disability Lawyer. What do you think about it?
I love this. I love it because it is anonymous. It's a drop-down menu. You plug and play a little bit of information just to see, to get a starting point on, you know, what are my disability rights? Do I have a claim here? And if you want to speak to one of us, you can. But if you don't, you can absolutely mark no, get out of your browser. We're none the wiser, completely anonymous. But at least it's giving you some information. It's giving you a starting point because this can be very overwhelming in dealing with your insurance company. And what we're really committed to doing at our firm is trying to push out as much free information, as many tools as possible to help people navigate this process.
DisabilityRights.ca, that is where you want to go. You want to find a radio station near you in your community that carries our radio show. Tamar does that as well. Got a lot of great callers every week on the show. We're going to play one back now, dissect it a bit, and always learn from it. So here we go. Listen up.
I'm currently on long-term disability, and I've fallen. I hurt my shoulder. I may have to have an operation for this. I'm wondering if this will affect my current LTD claim. I've been on disability now for almost a year with a chronic breathing issue.
What do you think, Val? What do you think?
Look, it shouldn't affect his claim. Obviously, he's been on disability and now he's sustained a further injury. In theory, all of this should be part of the full disability application and the basis for this individual to remain off work. But it can complicate it. This is why we get these calls and questions like this. Why? Because once insurance companies have your claim marked in under a certain category, and I think he describes for us this chronic breathing issue, they get tunnel vision. Okay, chronic breathing issue, it's going to be treated this way and that way. It therefore must mean that perhaps with further treatment, this individual can get off the books within that magic 2-year mark that we want to get him off of. And so we don't really want him getting involved in a fall and presenting other health issues to us, because it's going to take us off our track. And the track the insurance company has is to end that claim as soon as they can. And so what becomes critical when you have sustained another injury or another condition is to make sure that all of that medical information is available to the insurance company. And it can be difficult because, of course, when you're dealing with another injury and you've already got a chronic condition, treatment can be challenging, and it's going to be complicated in terms of what you do in terms of your primary health issues. And that is primary, folks. The insurance companies should, in theory, be secondary. But you can see that if you've got an ongoing disability claim, your insurance adjuster needs to know about it. Tell them. Let them know as soon as you can that you've been involved in a further injury, that right now it potentially looks like you may require surgery. That surgery is not yet scheduled. Timelines become really, really important to then force the insurance company to go off their path and suggest to them that, look, this potentially could be a claim that's going to go past the 2-year mark. They're going to have to look at this very differently than they normally would, even with a chronic condition, because once it comes to the change of definition, what if this individual, John, has not had the surgery yet, right? And so, yes, the policy changes, the definition may change in terms of that ongoing qualification, but at the end of the day, the insurance company is required to look at everything, all of the medical information together, and evaluate how all of those symptoms impact someone from being able to work or not work, and of course the policy provisions that go along with that. So it should not impact the disability claim, but it is important that the insurer know and that there's up-to-date information there.
And a good start. We'll take a short break here, get into our main topic on the other side, and that is the next steps when the insurance company cuts off disability benefits. Stick around for that. We will continue lots more of the disability law show. Stay with us.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Alrighty, welcome back to the Disability Law Show. We're going to keep going here. First, I always give you the contact information when we come back from a break to reach out to Tamar and her team. Phone number first, 1-855-821-5900. Toll free, consultations free, so make that call and back it up with the email, help@disabilityrights.ca. Okay, Tamar, into the main topic for this week. As promised, next steps when the insurance company cuts off disability benefits. Step number one, if you have it, well, you got to get it first, but review your insurance policy. Most of us have never bothered to even look at it, right?
That's right. And so, look, you get cut off disability benefits. It can be a very daunting, very nerve-wracking process. You're thinking, okay, where do I turn first? And we thought this is a really important topic because we want to give 1 or 2, 3 key things to do. And number one is insurance company is going to lob their insurance policy at you. They use the terms in their insurance company, in their insurance policy, as a means to cut off claims. So you want to read the letter they give you, and sometimes they make reference to provisions or parts of the policy in that letter, and sometimes they don't. And so this is why it becomes critical. Get the policy. Super easy. You just write for it. Don't call for it. Actually put it in writing, because there's a provision in our insurance acts, the different acts in the different provinces, but it's the same across the country. If you put it in writing to the insurance company and request a copy of the policy, not your booklet, the actual policy, they are required to release a copy to you. Now, you will be given a little bit of a runaround. This is why I said put it in writing, because most of the time they'll defer it to the employer. They'll say, well, get it from your HR, get it from your employer. That's not something that we typically will release, but they are required to. We actually have a really good memo on one of our websites, the ltdfaq.ca website, that gives you the steps on how to request it. But the bottom line is, the reason why it's so important is because if they are going to use parts of the policy to deny your claim, you want to, A, make sure that it's actually in your policy, because I've seen sometimes they reference the wrong thing, but B, you also want to make sure that you understand what they're saying to you. So if it's not in your policy, you should ask them as to why it's not in your policy, or ask them, where in the policy can I see what it is that you're saying to me as the reason why you're cutting off the claim. It's the starting point of all of our discussions with people who contact us, John, after they're cut off.
Is that the reason why they're so resistant? They Oz behind the curtain. They don't want to reveal the,
I don't know what it is. I think part of it is that they think it's proprietary, that it's a business document.
Right.
But at the end of the day, it's a contract. I mean, we talk about this on our employment shows all the time. You're entitled to your employment contract. Frankly, you're entitled to anything that you have rights under, like a critical illness policy, like a disability policy. And yes, the policy is between the insurance company and the employer, but you as employee, assuming it's a group plan, are a beneficiary under that plan. So yes, you are entitled to that plan. So get a copy of it.
Point number 2 is this: collect updated medical records. That's almost a no-brainer. Hate the term, but you should always have those.
Absolutely. There's no doubt about it. Even though they will put in the letter, look, this is why we denied your claim, sometimes we see things like, we don't think you're getting appropriate treatment, or we don't think it's severe enough, or I mean, I could go on and on about the number of reasons they can give you. But at the end of the day, if your own providers, treatment providers, doctor, physiotherapist, psychotherapist, whoever is in your realm treating you for your disability is still supporting that you cannot work, you want to make sure you have that in writing, okay? I cannot emphasize it enough, because it's harder for the insurance company to ignore when they have it in black and white on a piece of paper that this person cannot work because 1, 2, 3, 4, 5. And a lot of the times, insurers will not request that update before they cut you off. That's a problem for them. It would be a basis for a great claim, happy to take it on. But if you're trying to figure out, look, where do I go next once the insurance company has cut me off? Go to the doctor. Say, hey, doc, I've been denied. Did they ask for a request for an update? Did you send them anything? If you haven't, can you prepare something for me? Because no matter what you decide to do after you've been cut off, and look, and I hope it's to call one of us, but regardless, if they don't have the most up-to-date information, perhaps there's a new condition, all of that should be made available to the insurer no matter what. Really, really important.
And a bit of a sidebar to that, I know it's a legal show, not a medical show, but to get those documents and stuff from your doctor, I know my doctor, once a year, they send out that envelope saying, for $150 or $200, it'll cover all that. I think it's worth it for most people to pay the money just so it's easier.
I mean, look, this is the difficult part, is that in most provinces, doctors are not getting paid to do this kind of paperwork. Right. And so, yes, they do offer sometimes a fee-based service that includes all documentation, all reporting. Absolutely, if you're in the disability realm, you want to make sure that you're part of that process with your doctor. But also recognize that they're going to charge you something, and it's going to take time. So when you get cut off, don't waste time trying to, spin your wheels.
Got it.
Put the request for the policy in writing, and then go and see the doctor and understand what medical information is available. And if it's not up to date, get it.
Cut off benefits. Third thing you must do is this: seek legal advice. Right there.
I mean, I wanted to say it at point 1 and point 2, John,
exactly.
but it's almost like point 1. Look, we can help. And even if we can't help, we can help you understand what it is that they're saying to you in that letter. These consultations are absolutely free. It only takes one phone call, and we set it up, and within a couple of days, you've got an appointment with one of us to discuss what they're saying. And I think some of these things will be repetitive, perhaps, even if we do have that phone call. But a lot of these disability claims are case by case. They could be putting some technical reason to deny your claim or to cut off your claim. They could be using something that's not in the policy as a reason to cut off or deny your claim. And because we have so much experience in looking at these policies, we'll be able to tell you this in 5 minutes, maybe even less. And so there's no harm in it. But the better answer is if we can help you, then we can advocate for you and we can explain to you the process of what it means to involve us, which, by the way, also doesn't cost you any money because we work exclusively on contingency. And we can get the medical records and we will get your policy for you. And we will outline to the insurance company why they got it wrong, how their denial was premature or on an improper basis, and then leverage that to get you your benefits either reinstated or a significant payout to make you whole for however long you are going to remain disabled.
Main topic done. We got to take one more short break here. Well, on the other side, we'll get to a phone call, a couple emails as we roll on with the Disability Law Show. Stay with us.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back to the Disability Law Show. John Scholes here, by the way, and Tamar Agopian. Reach out to Tamar, disability lawyer, anytime you need to have a chat. Consultation won't cost you anything. The phone number always the same, 1-855-821-5900, help@disabilityrights.ca. And go to disabilityrights.ca to catch a radio station in your community that carries our 1-hour show. Tamar hosts that as well. I want to get to a call from one of our viewers/listeners. Listen up.
Is it common for the insurance company to offer you a buyout? I've been on disability for almost 3 years now with a pretty aggressive form of Parkinson's. I'm not sure whether I should take them up on this or continue as usual. It doesn't look like I'll be returning to work anytime soon.
Great question.
It's a great question.
Tempting, right?
It's so tempting.
Yep.
But it's never a full compensation, John.
Why would it be?
This is the thing. If they're trying to buy you out, it quite literally means they're trying to buy you off. And so you want to really be critical when you're being approached by the insurance company on this kind of a scenario. Now, there are many factors at play in assessing whether or not you should take a buyout like this. And health, of course, is primary. And so this caller tells us he's got Parkinson's. It's pretty aggressive. As I said at the top of the show, these types of conditions don't get better with time. And so I expect that he will likely be on the plan or the disability plan until the end. And the end is usually to 65 years old. I don't know how old this caller is, but the health condition, number one, and the age, number two, are two key factors in assessing whether or not this kind of a buyout makes sense for you. Because if you're 2 or 3 years away from age 65, why would you take less than 2 or 3 years? You want to get paid to the end. But if perhaps you're sort of 10 or 15 years out and perhaps you're frustrated in dealing with the insurance company, maybe you want to contemplate it. I mean, 99% of the time, I generally tell people it's not worth taking this kind of a buyout because they'll try and throw a lot of zeros at you and it looks big. And you're like, okay, this is fantastic. I don't have to deal with the insurance company anymore. But if you've got conditions that are not going to get better with time, and there's no likelihood of you returning back to work, then you do not want to leave any money on the table. You want to get every last penny of that. And so lots of things to consider, but I think the bottom line is that you want to get some legal advice. This is not a very common tactic, though I'm seeing this tactic more and more. And what insurers are doing is they're getting someone else in the company, not your adjuster, someone in another group, to send a letter out to you saying, this is what we're prepared to offer you. They'll give you just one number. They won't tell you how they arrived at that number. And then they'll say to you, but we think we should get some legal advice. We're going to give you a couple $100 to go and consult with a lawyer. And you should talk to your employer, make sure there's no impact there. And if you're ready to sign, here's a third paper and you go ahead and sign it, without providing any other explanation. And so, folks, it could have an impact on your employment. It could have an impact on your medical benefits. It could have all sorts of consequences. And I think you want to make sure that you've understood very clearly what's the math that goes into that number, what are those consequences. Don't just sign those documents. Contact us. Of course, we're happy to provide consultations in situations like this as well. And I mean, we'll bill the insurance company, don't get me wrong, but at the end of the day, you want to have sound advice from someone who doesn't have skin in the game. Yep. And I think that is the biggest challenge with insurers, is that they are very self-interested. The reason, the motive as to why they're going to offer this buyout is so that they can save money. And so if it's not beneficial to you, if you're not getting a certain percentage or period of time offered to you with this kind of lump out or buyout, then you want to be really, really wary about accepting it and accepting potentially a discount that doesn't align necessarily with either your age or your health condition or what your prognosis might be into the future.
I want to spend the last couple of minutes, get to an email here. Tamar from Taylor for this week says, I was on long-term disability after a serious accident. At the 2-year mark, my insurance forced me back to work in an accommodated role. I wasn't fully recovered, but tried for a year before going off again. Now they've denied my LTD claim, saying I can still do that job. Can they do that?
They can do it, but should they do it?
Right.
They shouldn't do it, okay? But they do. Why? Because it means that they don't have to pay you. So what Taylor tells us is that he managed to actually do this accommodated job, or at least work for a period of a year after he was pushed back to work. And the problem with that is he's probably past now the recurrence period under his disability plan. And so usually that period is about 6 months. If your health issues prevent you from working again, in theory, you should be able to get back on the plan, don't have to wait the waiting period, and your LTD benefits should start back up again. But the insurance company here, clearly clever, maybe they were in on it with the employer, I don't know, but at the end of the day, they pushed Taylor back to work prematurely, and now, after a year, he's not capable of continuing his job, and they are resisting the long-term claim. Yeah, surprise, surprise. It's probably because they're going to have him on until he's 65 years old, and they don't want that. So no, it's not something that they should do or shouldn't do. I mean, it's not appropriate, but they are going to look at this in a way where if the projection isn't looking good for Taylor in terms of reemployment, then we don't want this person on our policy and on our claim. So in circumstances like this, John, again, it goes back to the advice we've been giving throughout the show. The medical becomes really, really important. You want to make sure your doctors are engaged. You want to make sure the insurance company has up-to-date information as to why you cannot continue working, and you don't want to let this go. You want to fight this with one of us. Let us fight this. We can have a good outcome in the end, but we can't do it if Taylor doesn't reach out to us, and if he continues to, appeal or try and play ball with the insurer. That's not going to get him there. Get the denial, give us a call, let us help you.
Otherwise, he's a hamster in a wheel, so make that phone call and get it done, right?
That's exactly right, and that's the challenge, is that you don't want to be in that situation where you're forced back prematurely, and then in a situation where your health issues recur and you can't access the policy.
And that is it for this week's show. Thank you so much. Reach out to Tamar anytime. Consultations are free. 1-855-821-5900. Back it up with that email as well. help@disabilityrights.ca. Thank you so much for tuning in. We'll catch you next time on the Disability Law Show.